Welcome back to the channel. In prior videos, we talked about the different type of probate administrations that can be filed, whether it's formal administration, summary administration, or the various different other ones that can occur, whether it's from an in-state or an out-of-state setup. In this video, we are going to talk about some of the challenges that can occur when you are not filing for formal administration related to insurance. Now, irrespective of anything that we talk about in this video, when it comes towards filing taxes, that is the same process as we've talked about previously. After someone passes, you are going to file a final tax for them under their Social Security number, and then you are going to file a initiation and then subsequent years of taxes under the estate's name with an EIN number associated with the estate until the estate is closed out. So any earnings that occur that are associated to the estate will need to have taxes filed against them. This is primarily a conversation related to insurance. This information is coming from first-hand experience with making the mistake that I'm going to be talking about now. During the probate process, there might be an inclination or a decision to say, look, the homeowner policy is currently in the name of, say, John Doe. We are going through the probate process. Let's go change it to be the estate of John Doe as the insured person's name. I am recommending you do not do that because the fact that during the probate process, you will not have the letter of testamentary in order to open up an estate of John Doe account. As such, if you have it where you need to file a claim during the probate process, you will have no way to cash those checks. Therefore, you will need to hold on to those checks until after the probate process is finished in order to cash those checks, which, depending on the issue that occurs, that means that you will be out thousands of dollars waiting for the probate process to finish. If it is during a probate process that is associated with summary administration or anything other than formal administration, a estate of bank account will never be available to you because you will never have the letter of testamentary to open that bank account. Therefore, any of those funds associated to the claim will need to be added to the probate process, further delaying the probate process from completing. If you make the mistake and you do change the insured name to the estate of, there is only the two options. One, as I just mentioned, to have the claim funds added to the probate process as additional funds that need to be filed, and then paying out of pocket to the people helping with the repairs associated to the insurance claim. Or two, talking with the insurance company and then hoping they will be able to retroactively change back the name of the insured back to the person's name so that checks can be reissued to their name versus the estate of their name. So in the case with John Doe, have it where the policy name of insured is changed back to be just John Doe's name prior to the claim date so that they can reissue the checks. Now, that might not be something that can occur, but it can potentially occur if their legal department allows it. It is because of this that I'm giving you firsthand awareness to not change the name of the insured to the estate of through that probate process ever. If you are to change the name of the insured. It's because you are transferring the asset to somebody else, i.e., one of the beneficiaries. Now, if it's something related to a car, for example, if the car is registered under John Doe's name, but during the probate process, you now have it where you put insurance for that car under, say, your name, or one of the beneficiaries puts the car under their name while waiting to work through the re-registration process, that is something that the car insurance will allow you to do by adding that extra car, explaining the situation to them, as we discussed in a prior video. That means that the insured person will now be you or the beneficiary, because it's the driver that's being insured for that car. When it comes to real property, i.e., a home, if you change the name of the insured during the probate process, first off, there's a possibility that the home might need to get brand new insurance, and it might not be available because the fact some states have it where they go through transition periods and there's no longer availability for having insurance offered from that particular carrier, and you have to try to get insurance from somebody else. They're going to also want to make sure that the insured person is the owner of the property, unless it's being rented and then you're getting renter's insurance. But if you're getting homeowner's insurance, it's a little bit different. So it's a very gray area that needs to be worked out for that type of insurance. And you need to take some extreme caution while you're making the adjustments. And to add on to that fact, that after that probate process is finished, and if you're not selling the home and you're now giving it to a beneficiary, you might not be able to get a policy with that carrier. And the policy might now be more expensive because of the fact that you have to get it from a different insurance company. So these are all things that need to be taken into account when doing the transfer of the assets and transferring the insured to somebody else. As always, feel free to like, share, and comment on this video if this was beneficial to you. Feel free to share it with anybody else that you feel can benefit from this info. And look forward to seeing you in the next video. Thank you.